Medicinal marijuana cases are making their way to the family courts in California. Child Protective Services claim that a man who smoked pot 4 or 5 times a week for arthritis pain was endangering his child. The courts of appeals unanimously found no evidence that the father had a drug problem and that the child was well cared for. Is this something that we will be seeing more of in the coming years? Live at 5's family attorney Sonia Kaufman joins us now with the answer, plus answers to your questions regarding family law. Is this something we'll be seeing more of?
I don't think in Texas we'll be seeing that anytime soon.
But maybe Colorado and Washington, the two states that legalize the drug?
Maybe so. That's a real interesting phenomenon that it's crossing over into family courts. But I just have to say I disagree with that. The courts here would say that someone who smokes marijuana that much probably shouldn't have custody of their child. So that's a very interesting decision.
Well, we've got lots of questions, so let's go to our KFDM News Facebook page. This person posted, "My son's father passed away in early December of this year, and I need to get my son registered with Social Security for death benefits. He's only 13. Please help me get this ball rolling." Where does she start?
Well, I would contact the local Social Security office and they will direct her. It may be that the forms, she can download them online to speed that up, but that's what she needs to do.
Okay, the next question. Does a father that's paying child support have to continue paying if the child age 17 does not live in the home of the custodial parent and is pregnant?
Wow, that's a good question. I could see why someone would ask that. If there's an order saying that the father pays child support till the child is 18 or graduates from high school, whichever comes later, then that order is the order of the court. So if the father thinks that the circumstances warrant modifying that, then he needs to either go to the AG's office or go through a private attorney to come before the court. Just the fact that the child does not live at home with the parent who's receiving child support doesn't automatically mean that the courts will cut out the child support, however.
Okay. And how can you terminate parental rights on a person who owes $40,000 in back child support?
The short answer is you can't. The law in Texas is very clear that paying child support is not linked to visitation or custody. So they need to go about enforcing the child support, and if there are issues that say the father's rights should be terminated, that's a separate issue and they would need to file a termination case with the court.
Okay. We have an 18-year-old son with intellectual disabilities. We want to set up a special needs trust for him that won't interfere with his benefits in the future. Do we need to seek a specialized attorney, or can any attorney with estate planning experience do this?
That's a great idea. I think that's exactly what these people need to do, is a special needs trust, and an attorney who does estate planning is exactly who they need to speak with.
All right, Sonia, as always, we appreciate you stopping by. Unfortunately, we are out of time, but we will get to more questions in the new year, and we appreciate you stopping by.